Mr. Purcell?
Yes, Your Honor. May it please the Court. I'm Washington State Solicitor General Noah Purcell on behalf of the states of Washington and Minnesota. Your Honors, it has always been the judicial branch's role to say what the law is and to serve as a check on abuses by the executive branch. That judicial role has never been more important in recent memory than it is today. But the President is asking this Court to abdicate that role here, to reinstate the executive order without meaningful judicial review, and to throw this country back into chaos. The Court should decline that invitation. This afternoon, I'd like to first discuss why the Court should reject defendant's motion on jurisdictional grounds, and then explain why, even if the Court does consider the motion, the Court should reject it on the merits. So, starting with appealability, defendants have pursued the wrong remedy by seeking a stay in this Court rather than mandamus. Of course, so defendants have filed a notice of appeal and then a motion for stay pending appeal.
This is Judge Clifton. Why should we care?
Yeah.
I mean,
well,
is it your position a district court, suppose a district court issued an order requiring all the public schools in the state of Washington to be closed because of some concern about a flu epidemic, and did it in the form of a TRO and said the TRO would only last less than 14 days. Are you suggesting mandamus is the only form of relief available?
Well, Your Honor, I first want to answer why you should care, if you don't mind, before, because I do think it makes a big difference for two reasons.
You're basically saying we shouldn't look at it, and it's hard to me to envision an order this sweeping that shouldn't be subject to some kind of appellate oversight.
Your Honor, I'm not at all saying that you shouldn't look at it. Not at all. I'm just.
You've got a TRO that, by its terms, I mean, we've now received the proposed schedule, and the district court has entered an order, so we know already that this TRO is going to stay in place for more than the 14 days contemplated by Rule 65. So why shouldn't we view this as an injunction?
Well, for several reasons, Your Honor. First of all, in the cases where this court has treated a TRO as an injunction, the timeline of the order was vastly longer. In the SEIU case that the defendants have cited, the order lasted 4 months. Here, the order will be fully, the district court explicitly called the order a temporary restraining order, ordered a very quick, ordered the parties to confer and agree on a briefing schedule, and briefing will be complete within 14 days of the entry of the order. It could have been completed faster if the government hadn't filed this appeal and forced us to spend quite so much time on this. And the judge, I'm sure.
Time today as you want, but I'd suggest that this might not be the topic that's most important. But
fair enough, Your Honor. I would just say mandamus. The only point I'd make is that mandamus does allow review. It's just an extremely strict standard. And the important point also is that if the court treats this as an appealable order, then that's what the ultimate appeal of the ultimate ruling will be of. Whereas if the court properly treats this as a mandamus decision and sends it back to the district court will have the opportunity to enter a more full preliminary injunction when the district court understands that that's what it's doing, when that's its intent. And that will be what the court can ultimately review, as opposed to reviewing what the court clearly intended to be a temporary restraining order.
Yes, Judge Canby, in your view, if we left this order in place, would there then be a preliminary injunction hearing in the district court?
Absolutely, Your Honor. Absolutely. The parties have agreed to a briefing schedule. The preliminary injunction motion will be fully briefed by a week from Friday. I'm confident that Judge Robart will schedule a hearing and rule quickly after that. I'd also point out that the 14-day limit is for ex parte temporary restraining orders by its text. This one, part of the problem with treating this as a temporary restraining order, Your Honor, is that if the defendants are right that any time the court enters a temporary restraining order after a hearing and receiving briefing, it's treated as a preliminary injunction. That's a terrible rule to create for district courts, because it discourages them from hearing from the other side before entering a temporary restraining order. But Your Honors, I do certainly want to move on to the merits. I don't want to spend all your time on this. And of course, if this is treated as a motion for stay, we obviously still believe that the court should reject that motion. And the most simple basis for that, of course, would be the lack of irreparable harm. I heard Your Honors again pressing counsel for a statement of what the irreparable harm is, and still no clear factual claims or evidentiary claims of what that irreparable harm would be from a stay. And in fact, it was the executive order itself that caused irreparable harm to our states, to Washington and Minnesota and our residents, and to many other states and people, as described in the many amicus briefs that have been filed. So of course, we believe that the federal government has shown no irreparable harm from reinstating the status quo prior to the executive order.
What's the irreparable harm to the state of Washington?
From the executive order? Well, we detailed a number of irreparable harms, Your Honor. We had students and faculty at our state universities who were stranded overseas. We had families that were separated. We had longtime residents who could not travel overseas to visit their families without knowing that they would be able to come back. We had lost tax revenue. We had...
If we don't agree with your parents' patriae theory, then in balancing the harms and thinking about the standards for a stay or for a TRO, are we limited to looking at the proprietary interests of the state itself, or can we look beyond that, even if we reject the parents' patriae theory, or do you need the parents' patriae theory to expand the harms that we can consider?
I don't think the parents' patriae theory is essential, Your Honor. We've argued two independent grounds for standing. One, the proprietary harms that we're suffering, and one, the parents' patriae. So the court could certainly
say we agree with the proprietary theory for standing. Does that have any implications for what we can then consider when considering the factors for a TRO and for a stay? Or is it just a way to get standing and then we can consider anything in the public interest that affects the public interest?
I think it would primarily just go to standing, Your Honor, because I think the harms, well, I mean, maybe you would then consider the harms, the other harms in the balancing of equities and the public interest factor of the test, I suppose, as opposed to in the standing test, but certainly those harms would not become irrelevant. And again, it's now, at this point, it's really the federal government that's asking the court to upset the status quo. Things have slowly gone, are returning to normal, to the situation before the chaos of the executive order, and it's the federal government that's asking the court to upend that status quo again. And Your Honor, I think it's fair. Counsel for the government repeatedly sort of tried to limit the nature of our claim by quoting from our brief, and I think that misrepresents our claims to some extent in a way that's important, because the point we're making in the brief there about longtime residents is that this case is different from Mandel and Dinn in an important way, in that the federal actions here affect longtime residents who have been here. Now, that's not all it affects. It also affects people who are trying to visit them. It affects those people trying to visit their families. The Establishment Clause violation affects everyone in a sense, in the sense that as the court knows, the case law is quite clear that Establishment Clause violations on their own show irreparable injury, and we of course believe that claim is very strong. So just on the merits, the state has shown a strong likelihood of success. The federal government the states have shown a strong likelihood of success. And the federal government certainly hasn't met its burden on review of showing a likelihood of overcoming that showing.
Judge Canby, as far as the Establishment Clause claim goes, the government takes a position, I think, that in weighing the validity of your Establishment Clause claim, you're confined to the four corners of the instrument. What's your comment on that?
Your Honor, I think the case law shows that that's wrong. I think it was Judge Clifton who pointed out, or Judge Friedland, I'm sorry, or maybe both. Kerry versus Dinn says exactly the opposite. This court's decision in Cardenas says exactly the opposite, that if the plaintiff makes plausible allegations sufficiently supported of bad faith, the court can look behind the motives. And in those cases, just to be clear, those were cases where the case had to do with excluding an alien who had never been here and had no right to be here. So if anything, the court should take a harder look at the real motives in a case where there are significant impacts on people who do live here, who've been here for many years, who are longtime residents, and who clearly are entitled themselves to constitutional rights of due process and equal protection, unlike in Kerry and Mandel, where really it was, the rights being harmed were of the people overseas. It was the people here who were asserting them.
Well, we should be very careful about that. The assertion that the court took up the claim only because, in the case of Kerry versus Dinh, Ms. Dinh was a U.S. citizen. Of the number of people affected by the executive order, do you have any information as to what proportion would fit within the category of Washington residents or lawful permanent residents or people with visas? I mean, I suspect it's a small fraction.
I'd make 2 points on that, Your Honor. First of all, we are at the pleading stage. We have not had an opportunity. We filed a complaint and a motion for temporary restraining order, and so for standing purposes, all the plausible allegations in our complaint are treated as true. Now, we've alleged that there are thousands of people in Washington, thousands more in Minnesota, who are originally from these countries who are not yet citizens here. We know the way the order was originally interpreted, excuse me, Your Honor, defendants originally interpreted the order and said that it covered lawful permanent residents. We know that there are roughly 500,000 lawful permanent residents from these 7 countries in the United States. Now, they've changed their mind about 5 times about whether it applies to those people in the time since the order issued, and now they say that it doesn't. But at the time the state filed its complaint, they had not yet made their position clear about that, and I would say that that argument is not moot yet, because under the voluntary cessation standard, until they change the order to make that crystal clear, that claim, they can't just say, well, now we say it doesn't apply to them, so don't worry about it. I mean, that's 500,000 people who are in the United States who overnight, at least according to the government initially, lost their right to travel, to come in and out of the country, to visit their relatives. And several people.
Why shouldn't we limit the order, the temporary restraining order, reach to those people who you've got a strong case for, like the LPRs? Why should the temporary restraining order reach beyond that? That seemed to be the government's principal argument, that it was overbroad. Why isn't it overbroad?
For 3 key reasons, Your Honor. First of all, limiting the order in that way would not address all the harms the order is causing. So, for example, it would not remedy the order's violation of the Establishment Clause, which harms everyone in our states, as well as our states themselves, by favoring one religious group over another. It also would not fully remedy the order's violation of the Equal Protection Clause, because the order relies on discriminatory animus to deny some of our residents who are here the ability to receive visits from their friends and family, while allowing others to receive those visits, and so on. So it wouldn't address all the harms. The second point is that our U.S., as in Dinh, the U.S. citizens who are here, who are related to these folks overseas, do have rights, and it would not address their rights at all to limit it that way. And then finally, Your Honor, I just say that defendants have not explained how they would workably implement the narrower order that they're now proposing, which they didn't really propose in any way before. Their approach would require some sort of system for quickly approving travel and reentry by thousands of people from the affected countries who live here, who study here, who work here in our businesses, and who often have to travel for work or to visit family. And they just have not credibly described how they would be able to do that, even if it were able to address all of our harms.
In evaluating your Establishment Clause claim, should we apply Larson or Lemon?
Well, Your Honor, we think we prevail under either test, but we think this case is closer to Larson, because in Larson, what you had was a facially neutral law. It did not mention any religious denomination by name, but it did focus on religious groups, and the result of it was to distinguish between them in a way that favored some and not others. And that's exactly what we have here. We have an order that on its face doesn't mention any denomination, but that we have alleged, and there is strong evidence already to support, is intended to favor some religious groups over others. And that is exactly the situation in Larson. Now, I know the other side is saying if it doesn't mention a particular denomination on the face of the document, then Larson doesn't apply. But that's not what Larson itself says. In Larson, the law did not mention a denomination. But again, we also think that we prevail under the Lemon test, which is explained in some detail in our district court briefing. We did not, unfortunately, have space really to explain that argument as well in the briefing to this court.
If we were to agree with you about larceny, is there any reason to consider your equal protection claim, or are those two claims essentially redundant?
I think if you agreed with us about larceny, there would not be any need to reach our equal protection claim. I think that's fair.
Well, let me ask about the, I'll call this religious discrimination claim to reach both the equal protection and establishment clause claims. And I'm not entirely persuaded by the argument, if only because the 7 countries encompass only I think a relatively small percentage of Muslims. I mean, do you have any information as to what percentage or what proportion of the adherents to Islam worldwide are citizens or residents of those countries? My quick penciling suggests it's something less than 15%.
I have not done that math, Your Honor, but to be clear...
And given that all those countries are countries that have been previously tagged as subjects of concern about terrorism, granted, it's because of perhaps radical Islam sects, so there might be a religious motivation behind the terrorism, but I have trouble understanding why we're supposed to infer religious animus when, in fact, the vast majority of Muslims would not be affected as residents of those nations, and where the concern for terrorism with those connected with radical Islamic sects is kind of hard to deny.
Your Honor, the case law from this court and the Supreme Court is very clear that to prove religious discrimination, we do not need to prove that this order harms only Muslims or that it harms every Muslim. We just need to prove that it was motivated in part by a desire to harm Muslims. And we have alleged that... How do
you infer that desire if, in fact, the vast majority of Muslims are unaffected?
Well, Your Honor, in part, you can infer it from intent evidence. I mean, there are statements that we've quoted in our complaint that are rather shocking evidence of intent to discriminate against Muslims, given that we haven't even had any discovery yet to find out what else might have been said in private. I mean, the public statements from the president and his top advisors reflecting that intent are strong evidence, certainly at this pleading stage, to allow us to go forward on that claim. And again, you know, with no type of discrimination claim requires you to show that every single person of that category was harmed by the action. You just have to show that the action was motivated in part by a desire to harm that group. And that's exactly what we've alleged.
Any situation where the proportion affected were less than 15%?
Your Honor, I'm sorry, I haven't thought about, as I said, I had not done that math before the argument. I have not thought about the case in those terms because...
Well, let me switch to the other part of it. I mean, do you deny that, in fact, there is concern about people coming from those countries, separate and apart from what their religion might be, because, as Congress and the previous administration have concluded, those countries are a concern from a terrorist perspective? Your
Honor, Congress had determined that those, and the executive had determined that those countries, as I think it was you who put it, should not, you know, get a waiver from a visa requirement. That is eminently different from a complete ban on travel to this country.
Do you assert that decision by the previous administration and by Congress was religiously motivated?
No, Your Honor. No, we are not asserting that at all.
So it would be possible to identify these countries as a source of concern and possibly as the subject of special treatment without having religious motivation or discriminatory intent behind it.
Well, Your Honor, but cases like McCreary from the U.S. Supreme Court make very clear that in assessing Establishment Clause claims, an action that could have been perfectly legitimate if done with proper intent is not legitimate and is unconstitutional if done with a desire to favor one religion over another. McCreary makes that very clear. It literally says the exact same action could be acceptable if done for some reasons and not acceptable if done for others. And here we've alleged very plausibly with great detail that this was done to favor one religious group over another. And so we should be allowed to go forward on that claim, even though, yes, we're not denying that these countries could have theoretically, and in fact were previously chosen for some lesser level.
It's not just your allegation at this stage. You've got to demonstrate a likelihood of success. So what is it that should lead us to conclude that you've got a likelihood of success of being able to prove the religious animus you allege?
Well, Your Honor, for starters, that the president called for a complete ban on the entry of Muslims, and then
is this that ban?
No, we're not saying that this is a complete ban on Muslims entering the country. Obviously, I mean, they realize that I mean, this is well, what his advisor said on television was that he was asked for a way to implement a narrower thing that would be legal. And but the point is that that was clearly a motivating, what we have alleged. And again, yes, it is. We do have to show a likelihood of success. But at this stage, the case law is clear. Our plausible allegations are taken as true for assessing that likelihood of success. And
wait a minute, that cannot possibly be true. We are supposed to take your word for it. The fact that you make an allegation of the complaint and that equals likelihood of success, you don't really mean that, do you?
Well, Your Honor, what I mean is that we have assessed, we have alleged.
You can allege anything. Do I have to believe everything you allege and say, well, that must be right? That's not the standard.
You've actually supported these allegations with exhibits, haven't you?
We have supported many of our allegations with exhibits, yes, Judge Friedland, we have, and I do think that's important. We have presented an enormous amount of evidence, especially considering, again, that the time between our filing, our complaint was filed a week ago Monday, together with the temporary restraining order motion, together with the declarations. So unlike cases, we've had extraordinarily little opportunity to actually gather and present evidence in the district court.
We faulted the government for exactly the same thing. Don't tell us you need more time because the government brought the stay motion. Well, don't tell us you need more time. You're the one that sought the temporary restraining order. Either you have the evidence presented in the record or you don't. I mean, don't tell us maybe you'll gather it later. If you can't demonstrate a likelihood of success of what you've got in the record so far, and maybe you can. I'm not saying you can't. But so far, I haven't heard a lot of reference to evidence and a lot more references to allegations, and I don't think allegations cut it at this stage.
Well, Your Honor,
this is Judge if the motion before us is a motion for stay, who has the burden of showing likelihood of success?
At this point, Your Honor, it is the federal defendants who have to show that they are likely to succeed on appeal. We had the burden at the district court of showing a likelihood of success on the merits. But the stay standard is very clear that it's the party seeking the stay that has to show a likelihood of success on appeal. And again, we believe that it would be more appropriate to treat this as a mandamus action where they would have to show a clear and indisputable right to relief. And in part, we think that because if you don't, then it's the district court's temporary restraining order that the federal government is going to maintain is the order to be appealed from ultimately. And that's just not proper, given that in neither form nor substance or intent was that meant to be a preliminary injunction order. It was meant to be a temporary restraining order. The district court was very clear about that. And the district court should have an opportunity to consider the preliminary injunction briefing and issue a preliminary injunction order that could then be reviewed very soon.
Is there more evidence that is necessary, though? I mean, I think most of your claims are going to get de novo review anyway. So I don't know if we really need to wait for the district court to do more unless more evidence is going to be presented.
Our point is not, well, we do intend to file some additional declarations and evidence in the district court if given that opportunity. But I think it's also important to point out, just for fairness, the sake of fairness to the district court itself, the district court should have the opportunity to enter something that it actually thinks is a preliminary injunction order, so that to assess the evidence, to have more time to issue an order that's framed as and intended as a preliminary injunction order that this court could review. And if I guess I'd just ask that if you decide not to do that, if you decide to treat this as a preliminary injunction ruling and a stay motion, then I'd ask you to issue an opinion that treats it like a preliminary injunction ruling and that gives it the sort of consideration that you would want that reviewed with, because the other side, that the federal government has already made very clear that they intend to seek immediate review if this court denies the stay. And of course, you know, it would be unfair to this court and to the district court to have the federal government try to take to the U.S. Supreme Court, you know, an order that was explicitly framed as a temporary restraining order, and that the judge understandably issued urgently.
If we were to issue a reasoned opinion, would that take care of this concern, or is there a concern beyond that?
I think that would address much of the concern, Your Honor. I would ask that you do either one or the other. I mean, I do think it would be better procedurally and more in keeping with the court's precedent to send the case back to the district court to find this temporary restraining order to allow us to put in the evidence that we would to support the preliminary injunction motion and to allow the district court to issue a preliminary injunction ruling. But if you're not going to do that, then I do think a reasoned opinion would do much to address that concern.
Can you tell us whether your further evidence would be more about standing or more about the merits or both?
Your Honor, I think it would be primarily just slightly more detail about standing at this point. Again, we haven't. Of course, the difficulty with a claim that's about intent is that we've made these allegations. We haven't had any discovery yet, and realistically, it will take some time to gather that sort of evidence beyond public statements. And this court has held, and so has the U.S. Supreme Court, that when a case has to do with intent, it's remarkable to have this much evidence of intent without any discovery, I think is probably the best way to characterize it. So I think that the court should keep that in mind in assessing likelihood of success.
We've taken you down to 4 minutes. Is there anything you'd like to conclude with?
Well, Your Honor, the other point, I guess there's one other point I would like to make, that of course we also have a statutory claim under the Immigration and Nationality Act, and we believe that all of our claims are very strong, that we're likely to succeed on all of them, but that is a claim that we feel very likely to succeed on, and that would also potentially allow the court to avoid the constitutional issues if it wanted to by relying on the statutory ground. The INA section, sorry?
But the statutory ground would help us only with regard to those seeking immigrant visas, is that correct?
Yes, Your Honor, I think that is largely correct. I think that is basically correct, that 1152 speaks of immigrant visas and that there cannot be discrimination based on nationality in issuing those visas. And so by extension,
really
that would not seem to help us.
That's not really a way to avoid all your constitutional claims then, right? Because it wouldn't cover everyone?
I suppose that's fair, Your Honor. It would not necessarily allow you to avoid all the constitutional issues, but I guess I just don't want to lose sight of that claim, that it is, we believe it is a very strong claim that the order violates the INA, and also I think it's important I think that's an important point because it goes to what level of deference is owed to the executive. Of course, the president is claiming that he's acting pursuant to a congressional delegation of authority, and our position is, in fact, no, he's acting contrary to what Congress has said. And even if that's not as to every single member, every single person who's harmed by the order, it's an important factor to consider in deciding how much deference to give to the executive on this point.
Well, there have been presidential orders in the past by prior presidents that treated people based on their nation. Why shouldn't that suggest to us that the statute should be harmonized in a way other than the one that you're advocating?
Well, Your Honor, all of those orders have been narrower, significantly narrower than the one here, and included.
The same, though. I mean, if you single out Cubans because they're from Cuba, that's doing it by a class based on nationality, and I haven't heard any citation or reference to a legal challenge to that, or an argument that, I think that one was President Reagan's, that what he did wasn't appropriate. There were others that singled out individual countries. Hadn't been a challenge to that. Why should we decide that Congress, in enacting 1152, since that's the number I've been using, meant to amend or partially repeal 1182?
Well, Your Honor, 2 points. Number one, as you pointed out, there have not been cases about those issues. So there's not. While that may have been to some a much narrower practice than this, I agree that there has been some practice to that effect, much narrower than here. But again, every one of those examples involved much more narrow tailoring than we have here, and also 1182.
But the problem is the same. Can you treat people based on the nation they come from? And foreign policy or foreign affairs do all the time. We treat people from North Korea differently than we treat people from France. So I have trouble understanding your interpretation of 1152 as prohibiting what seems to be commonplace in foreign affairs.
Well, Your Honor, 1182 itself includes a number of exceptions that allow that allow the federal government to deem people inadmissible for security-related reasons and other reasons, but not to make this sort of across-the-board, without exception policy that applies to infants, to school children, to grandmothers, to people who pose no plausible threat whatsoever to this country. So I guess I just ask the court not to lose sight of that statutory claim, especially because I do think it helps drive home that the court can review this order. The court should review this order and should give it the constitutional and statutory scrutiny that it deserves. If the court has no further questions, we would ask that you, well, first we'd ask that you treat this as a mandamus writ and deny it. But if you're going to treat it as a motion for stay, we'd ask that you deny it and issue a reasoned opinion doing so. Thank you.
Thank you.